All right. Good evening, folks. Welcome to Monday Night Law. Kirk's Law Corner here. Hope everybody had a good, safe Independence Day. It is not 4th of July, it's Independence Day. We declared our independence from Great Britain. I remind people that the fireworks is to resemble the cannon fire and all the firing of weapons, the bangs, the Revolutionary War. We fought to separate from tyranny, which last Monday I covered the Declaration of Independence. Now, I'll pull this up here. Okay. I can see that. All right. So, I wonder if that's going to have all. I'm going to go over a couple of different documents here in the beginning of our history, creating our government. And that was a lot of people talking about the Mayflower Compact, the Mayflower Compact. We're going to go over the Mayflower Compact. But it's really short. Much, much, much shorter than a lot of people allude, which makes me leads me to believe that people haven't even actually read the Mayflower Compact. They don't even know what it says, because a lot of people talk about it like it's some big, huge document. And, oh yeah, it's the Mayflower Compact, man. It's it's all this big stuff, and I'm just like, no, it's not. As we will see. On my good old website here, the avalon.law.yale.edu, under the 17th century, which is 1600 to 1699, the 1600s. The Mayflower Compact was done in 1620. This is an agreement between the settlers at New Plymouth. Whoa, wait a minute. See? Not very big. Honestly, it's basically, I thought it was 3 sentences, but it's kind of one big run-on sentence. Well, I guess there is a period at the end. So let's read what it says. In the name of God, amen. We, whose names are underwritten, the loyal subjects of our dread sovereign Lord King James, by the grace of God, of Great Britain, France, and Ireland, King, defender of the faith, etc., having undertaken for the glory of God an advancement of the Christian faith, and for the and advancement of the Christian faith and the honor of our king and country, a voyage to plant the first colony in the northern parts of Virginia. Everybody's been taught that, oh, well, the Mayflower Compact, that was when our first settlers came here. Really? This is 1620. What about let's see. How about How about the first charter of Virginia, April 10th, 1606? Wait, 1606? That's right. How about the second charter of Virginia? 1609. Where's that? Here, it should be right here. Second charter of Virginia, May 23rd, 1609. What about the third charter of Virginia, March 12th, 1611, 1612? Huh. Virginia. That's right. Because Virginia was a very large territorial mass. But if we look closer, it says the northern parts of Virginia. That's not the first colony. That's the first colony in the northern parts of Virginia. Virginia was already a very large territorial mass under the first charter of Virginia. Jamestown, Virginia was originally settled in what I have found was clear back in 1603. So, do by these presents, solemnly and mutually in the presence of God and one another, covenant. Covenant. And combine ourselves together into a civil body politic for our better ordering and preservation and furtherance of the ends aforesaid, which is for the glory of God and advance of the Christian faith and the honor of our king and country. That's the aforesaid. Or technically speaking, do by these presents solemnly mutually in the presence of God and one another covenant, and combine ourselves together as civil body politic. For our better order and preservation and furtherance of the aforesaid, and by virtue hereof do enact, constitute, and frame such just and equal laws, ordinances, acts, constitutions, and officers from time to time as shall be thought most meet and convenient for the general good of the colony, unto which we promise all due submission and obedience. In witness whereof we have hereunto subscribed our names at Cape Cod the 11th of November in the reign of our sovereign Lord King James of England, France, and Ireland, the 18th, and of Scotland, 54th, Anno Domini 1620. Then we'll look at 1621, the actual ordinances for Virginia. An ordinance and constitution of the Treasurer, Council, and Company in England for a Council of State and General Assembly, July 24, 1621. Now, this is the document that starts to create our form of government here in America. Okay? An ordinance and constitution of the Treasurer, Council, and Company in England. It's a constitution, it's not a charter. Constitutions are instruments of government. So this is history of law. This is the creation in 1621. This is how things got started here in America. This is American law. While it might be under the British Crown still, What was the intent? Christianity, not Catholicism. To all people to whom these presents shall come, be seen or heard, the treasurer, council, and company adventurers and planters of the city of London, for the first colony of Virginia, send greeting. Know ye that we, the said treasurer, council, and company, taking into our careful consideration the present state of the said colony of Virginia, and intending by the divine assistance to settle such a form of government there, as may be the greatest benefit and comfort of the people, and whereby all injustice, grievances, and oppression may be prevented and kept of as much as possible from the said colony, have thought fit to make our entrance by ordering and establishing such supreme councils as may not only be assisting to the governor for the time being in the administration of justice and the executing of other duties to this office belonging, but also by their vigilant care and prudence may provide as well for a remedy of all inconveniences, growing from time to time, as also for advancing of increase, strength, stability, and prosperity of the said colony. So, we grasp the concept of government being instituted here, form of government. We, therefore, the said treasurer, council, and company, by authority directed by to us from His Majesty under the great seal upon mature deliberation, do hereby order and declare. See, we're declaring, laying the law down. This is law. That from henceforward there shall be 2 supreme councils in Virginia, for the better government of the said colony aforesaid. The one of which councils to be called the Council of State, and whose office shall chiefly be assisting with their care, advice, and circumspection to the said governor. This is kind of like what we have today, a council for the governor, or a council for the president. Interesting that something from 400 years ago, 403 years ago, still exists in our form of government. This is where it came from. Shall be chosen, nominated, placed and displaced from time to time by us, the said treasurer, council, and company, and our successors. So, when we're talking about reassembling government de jure, and we're talking about we need the people to come together and we elect these particular positions, these are the ones we're talking about at a state level. This is what we have to do here, and it's interesting that it talks about a covenant, because that's one of the documents that we have to do is a covenant, because a covenant is unto God. The oath is to the people. Okay? Now, imagine that we're in this situation that we're in now, and we have to completely reassemble government de jure. Lawful government. Lawful, full of law. This is law. Not statutes, not Roman civil law, the code. No, this is law. They don't want you to know this, although it's out here for us to read. Here it is. Finding that needle in the haystack, well, that's what this is. Which council of state shall consist for the present only of these persons. Okay, these persons, as are here inserted. Sir Francis Wyatt is Governor of Virginia. That's the person. Captain Francis West. Sir George Yeardley Knight. Sir William Noose Knight Marshal of Virginia. Mr. George Sandys, who is the treasurer. Mr. George Thorpe, duty of the college. Captain Thomas Neese, deputy for the company. Mr. Paulette, Mr. Leach, Captain Nathaniel Powell, Mr. Christian Davidson, secretary. Dr. Potts, physician to the company. Mr. Roger Smith, Mr. John Berkeley, Mr. John Rolfe. Which said, counselors and council, we earnestly pray and desire, and in His Majesty's name strictly charge and command that all factions, partialities, and sinister respect laid aside, they bend their care and endeavors to assist the said governor. First and principally in the advancement of the honor and service of God and the enlargement of His kingdom amongst the heathen people. And next in erecting of the said colony in due obedience to His Majesty and all lawful authority from His Majesty's directions. And lastly, it's all lawful authority. And lastly, in maintaining the said people in justice and Christian conversation amongst themselves, and in strength and ability to withstand their enemies. In other words, defense. And this council to be always of the, or for the most part, residing about or near the governor. The other council, more generally to be called by the governor once yearly and no oftener, but for very extraordinary and important occasions, shall consist for the president of the said council of state, and of 2 burgesses out of every town, 100, or other particular plantation to be respectively chosen by the inhabitants. Which council shall be called the General Assembly. This is the first document in history for America that creates the General Assembly. Now, if you'll notice that it's the other council, the more generally to be called by the governor once yearly and no oftener, but for very extraordinary and important occasions. We still call it the General Assembly today, the state legislature. It's still called the General Assembly because of this document right here, creating our form of government. And it's done by the inhabitants, or the people. And we're supposed to have what? And of 2 burgesses out of every town per 100, or other particular plantation. Wherein is also in the said council of state, all matters shall be decided, determined, and ordered by the greater part of the voices then present. The General Assembly, what we now refer to as the legislative branch, does all that. All matters shall be decided, determined, and ordered by the greater part of the voices then present, reserving to the governor always a negative voice. Gee, isn't that what we call the gubernatorial veto today? That's right. That power still exists. That the governor has the authority to veto any legislation that comes through. And this General Assembly shall have free power to treat, consult, and conclude, as well of all emergent occasions concerning the public weal of the said colony and every part thereof, as also to make, ordain, and enact such general laws and orders for the behoof of the said colony and the good government thereof. And shall from time to time appear necessary or requisite. Whereas in all other things are required the said General Assembly, as also the said Council of State, to imitate and follow the policy of the form of government, laws, customs, and manner of trial, and other administration of justice, used in the realm of England, as near as may be, even as ourselves, by His Majesty's letter patent, are required. What manner of trial? You mean like grand jury indictments and all that kind of good stuff? In 1621? Yeah, that's right, because the right to trial by jury actually came from the Aziz of Clarendon of 1166. Further stated in the Great Charter of Liberty, Magna Carta, 1215. That's how that's supposed to be done. Clear back into 1166 to 1215 to all the way through right here to 1621. Provided that no law or ordinance made in the said General Assembly shall be or continue in force or validity unless the same shall be solemnly ratified and confirmed in the General Quarter Court of the said company here in England, and so ratified, be returned to them under our seal. So there was definitely a little bit of oversight going on here. Everything that they did law or ordinance-wise had to be sent over to the General Quarter Court of the said company here in England, and so ratified, and then be returned to them under our seal. It being our intent to afford the like measure also unto the said colony, that after the government of the said colony shall once have been well framed and settled accordingly, which is to be done by us, as by authority derived from His Majesty, and the same shall have been so by us declared, no orders of court afterwards shall bind the said colony, unless they be ratified in like manner in the general assemblies. In witness whereof we have hereunto set our common seal the 24th of July 1621, in the year of the reign of our sovereign Lord, James, King of England, etc., the whatever, and of Scotland, the of Ireland. It's all that stuff. Yeah. This is like a footnote here. The text is from the history of the first discovery and settlement of Virginia by William Sis, Sabian's edition, New York, 1865. But how is that the first discovery when I've already covered this before, and I just showed it again. The first charter of Virginia, 1606, which was Jamestown, Virginia. Very interesting how they try to twist this stuff. Oh, but what is this? Appendix 4, the Commission of Sir Francis White, Governor of Virginia, in regard to the ordinances printed in Henning's Statutes at Large. The First Assembly of Virginia was convened July 3rd through August 9th, 1619, at Jamestown by Governor Yeardley, under the authority of the Virginia Company, executed in November of 1618. This document, either a commission or instructions to Yeardley, has not been found, but probably was similar to the latter ordinance of 1621. For a report of the proceedings of the First Assembly, see Colonial Records of Virginia, Senate Document Extra, Richmond, 1874. But it's right here. First charter, second charter, and third charter. How do we not know that? It's like they just totally skip over that and want to start with 1621. Like, none of this existed. Well, how did those people that were sailing over here settle in the northern parts of Virginia if Virginia wasn't already created? The Virginia Company was already here, up and going for how many years? We're talking 1606, which my research shows that Jamestown was actually established in 1603. So roughly 17, 18 years of history prior to this ordinance. Prior to them coming here and settling in the northern parts of Virginia. Wouldn't Virginia have to exist prior to, in order for them to settle in the northern parts of Virginia? I mean, that just makes logical sense to me. Yeah, Walter, we're not even going there yet. We're still talking about form of government and the several parts of that and how it's created. And this is the document that creates it. So now we need, this is what we need to do to reassemble. This is what we're reassembling. The council, the general, part of the General Assembly. It's, again, back to building an engine. It has to be done this particular way. Due process of law. The law dictates this process. Not our feelings. Not our opinions. Because there's some other people out there that have their own thoughts and opinions and think they can just arbitrarily take up the governor and all this stuff. Well, the governor has to be elected by the people. Cannot just assume that position. That is an elected position. And has to be elected by the people. Of the people, by the people, for the people. That's an odd question. Uh, weren't there? Oh, well, where'd it go? Weren't there already natives here? Many places founded, not built. I'm not aware that there was. Not for meeting this. Now, there's some very, very, very interesting stuff when we're talking about Tartaria, mudflood, and ancient civilizations. Sure. But if you're leading to the whole Indian argument, they never settled and had civilized societies. They had, not only that, they were murdering each other. I mean, that's just part of human nature. That's one of those facts that a lot of people don't want to admit or talk about. And again, we had what I like to refer to as 3 different kinds of people that came here. You had the red coats, the blue coats, and the no coats. Again, I'm going to reiterate, red coats, blue coats, and no coats, because they didn't have, they were just regular men and women, good Christian people trying to flee Great Britain, England, trying to flee that frickin' Catholicism for religious separation. Tired of the tyranny going on over there. That's what they were fleeing from. So you want to talk about like refugees. But I'm not aware of any actual forms of government, settled civilized societies. Other than that, this is what the law is. This is what it says. I know that some land was purchased. So there's an agreement for land if there was such a claim on the land, which in a way kind of seems a little weird because God created the land and God gave us dominion over the land, mankind. But the thing is different kinds of people were coming over here for different reasons. Some for good reasons, some for bad. And I want to reiterate again, the red coats and the blue coats. Now, what's the colors for our so-called parties that we have today, our two-party system? Isn't it red for Republican and blue for Democrat? No, I wouldn't say that they brought what they were fleeing from with them. You got to look at the source of where it really was coming from, which ultimately is the Jesuits, who for hundreds and hundreds of years, thousands of years, want world domination. They want control. Talk about a one world government. That's the Jesuits. Truth be told. But a lot of people don't go that deep into research and get to the root where it really comes from. And then we can even get in further. We can go a little bit deeper into, I mean, it's aside from just the Jesuits alone is the one that's really conducting all of this, that has all the money and controls the banks and basically they're the puppet masters. But then we get into the alien stuff. And that's, again, that's it, that's a deep, really deep rabbit hole that many can't even begin to fathom. As you notice, I don't talk a lot about that kind of stuff on here, just for the simple fact that, well, I'm not super knowledgeable on it. I haven't studied it well enough where I can speak it off the top of my head like some of this stuff where I have read this particular document. I've read this a few times. So I already know what it says. I already know what it created. And that this is the origin of the General Assembly. But the thing is, that's why I wanted to want people to comprehend that there were at least a minimum of 3 different kinds of people who came over here. The red coats, the blue coats, and the no coats. Right? And then there was, agreements with the Indian tribes there. They made alliances and trade, and of course then you've got bad guys in there. Traitors, evildoers. Sabotaging the whole thing. So, to say all men did this to the so-called native Indians would be a lie. Just as much of a lie as all Americans are bad because of NATO. Because of the military-industrial complex, which was all created, the Tri-City state, London, Vatican, and D.C., District of Columbia. So, if you're an American, you're bad because you went around the world and our military under NATO, this military-industrial complex, has literally human trafficked, murdered, raped men, women, and children of all ages. That's the same concept. And I can tell you right now, I wasn't a part of any of that. But I have seen videos from people from other countries that, death to America. Death to Americans. Because that's what they've been led to believe. See, these Jesuits or whatever, pulling the strings, put out the narrative so that we fight each other to cause division. So that we fight amongst ourselves and kill one another with ease, just the stroke of a pen or somebody whispering in somebody's ear, and there it goes. It just, yeah. Well, the thing is there's a lot of people all over the world, okay, that are waking up, that are tired of the corruption, tired of the tyranny. Again, and this is a worldwide event that's happening, folks. And it is a revolutionary war. We are at war. Worldwide, but you want to talk about World War III, we're in it. We're at war, make no mistake. And it's a world war. Worldwide. Now, they limit us through the internet, obviously. from seeing other people's nation state countries, whatever you want to call them, any of their podcasters, news, legitimate stuff, regular people and their videos. That stuff is pretty limited. I mean, can you imagine if it was all intermingled? Like, okay, you have Facebook for USA. You have Facebook for different countries. So you don't really see a lot of things going on in other nation states or countries unless somehow it kind of crosses over. It doesn't come across our feed naturally. So in a way, they're controlling the information that we see. Now, there are most certainly different sources to see some of this stuff. It does happen. It does come out every once in a while. So the thing is, yes, Walter, the name Virginia originates from the Virginia Company. Yep. So there's, all this stuff that's happening right now. It takes time. And I'm going to reiterate what Trump said, was that this was much bigger than they thought. And it's going to take time. Now, if you think that nothing has been happening, you're completely in the dark. And now, if you think that, well, some things might have been happening, you're still in the dark. If you don't know at this particular point in time that there have been several nation states that have been invaded, disassembled, taken down, corrupt government, instituted new governments, held elections, and done treaties of peace. This all started clear back in December 20th of 2017 with the Executive Order 13818. That's what that executive order was about, and still is happening. There have been many people who have been executed. That's a fact. Again, these are things that are not out in the general public knowledge. You have to read between the lines. You have to pay attention to know what's really going on. That this is in fact happening. Otherwise, you're in the dark. You're not awake yet. There's a lot of people who think and proclaim that they're awake. Awake to what? Right? I know that's one real raw news. A lot of people just dismiss it because, well, it's all for satire. Read their disclaimer. Yeah, read their disclaimer. I haven't been back since here just a month or so ago, but they changed their disclaimer again. And when I first found Real Raw News, what did it say? It said, some or all of this may be true, but is to be considered as satire. Let me repeat that. Some or all of this may be true. Now, there was a time there where when Trump was still acting president, commander-in-chief, which he still is the commander-in-chief. There is no president because there is no corporation. There is no government. We're under a continuity of government. So the DOJ tried to stop Trump from doing any more executions. Okay, how does say the DOJ try to stop something from happening that's already happened if it hasn't happened? I mean, that this is just logic and reason. Okay, reasoning this out, that there is executions that had been happening and have been happening. How would they try? Why would they try to stop him from doing something if it wasn't happening? Oh, Jax on YouTube. Apparently YouTube's working this week. Every week in New Jersey, they are arresting teachers for being child predators. Gee, it's getting down to local level, finally. It is happening, folks. And more people are starting to see it. Very few, but there are more and more people waking up to the truth of seeing it actually happen. Okay? So those are just a couple of things on form of government. And trying to wake people up, to lead them to the water, right? Can only lead a horse to the water, but I can't force them to drink it. So that's what I'm doing. I'm trying to lead men and women to the water to become one of the people. Not American state nationals, because that's all a fraud. That's all part of the code. All shit made up after 1871, 1878. It's all part of the scheme, scam, and fraud of Anna von Reitz and her kind over there trying to dupe the people. But the problem is the corporation is done. So now they're screwed. Because remember, essentially, the code is the bylaws of the United States Inc. Corporation. Those are corporate bylaws. So when the corporation went down, so did all of its bylaws. Now, Michigan did the 21 requisitions, the legitimate government de jure that's been reassembled out of Michigan was 2012. One of the 21 requisitions was to abolish the Reconstruction Acts. So, how many people comprehend what that actually means? And I mean fully comprehend. Think about that for just a minute. Think about it. If you make void something void, everything that was created after that is all gone. It's void for any effect. Now the code, that Code of Civil Procedure Act of 1873 by Congress, isn't that after 1871? After 1868? Doesn't that make that void? I think it does. So, right, James, no new contracts, right. But the fact is they have no more power. The power's been stripped from them because the code creates all of that stuff. Now I still see people out here hooting and hollering about the Chevron, the Chevron. Whoopee. They're still recognizing the Administrative Procedures Act of 1946, which subverts the law, the common law of the land, and going with the Administrative Procedures Act of 1946, stating that the judicial branch is the one that's supposed to do the review of these executive agencies, when in reality, the right dictates the legislature. The common law of the land dictates that the legislature is the one that's supposed to do the investigation to see if they've exceeded the laws of their creation. The legislature is supposed to make the laws of its creation. They're still holding on that these executive agencies have the authority to make their own laws of creation. And then the judicial branch is supposed to provide oversight or review of any agency action, final determination. All that case did, and it wasn't a Chevron case. I think I still have that pulled up. Loper Bright. Loper Bright Enterprises, blah, 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 blah. Okay. Basically what it was that the Chevron decision from, was it 1986 or whatever it was there, all it did was say, oh, well, that the judicial branch, the judges, are the ones that are supposed to make the decision on interpreting the so-called statute. So a lot of people are making this out to be a whole lot bigger than it really is. And no, it's really not. It's the Chevron difference is inconsistent with the directions Congress gave us in the Administrative Procedures Act. It represents a grave anomaly when viewed against the sweep of historic judicial practice. The decision undermines core rule of law values ranging from the promise of fair notice to the promise of a fair hearing. Even on its own terms, it has proved unwokable and operated to undermine rather than advance reliance interests, often the detriment of ordinary Americans. And from the start, the whole project has relied on the over-aggressive use of snippets and stray remarks from an opinion that carried mixed messages. Stare decisis, true lesson today is not that we are bound to respect Chevron's startling development, but bound to enter it. Basically, it's just saying, and where is it? Citing Blackstone, imagine that. See how they keep citing Blackstone? Book 1, subsection 69. You know, again, I cannot reiterate this enough. They're going back to fundamental principles, and they're going back to Blackstone's Commentaries on the Law of England. It is an extremely good read. Where is it? Yeah, like this. Even if all that and everything else laid out above is true, the government suggests we should retain Chevron deference because judges simply cannot live without it. Some statutes are just too technical for courts to interpret intelligently. That's in the dissenting opinion in overturning the Chevron difference. You know, we need to get back to real law and due process of law. We need to get rid of this administrative law, which was created by the bar. We're not supposed to have administrative law. We're supposed to have common law. Common law is our fundamental law. But again, you have to know this. You have to know that the bar is the one that infiltrated. Yeah, I'm trying to find where it talks about what it was. If Chevron meant to usher in a revolution in how judges interpret laws, no one appears to have realized it at the time. Chevron's author, Justice Stevens, characterized the decisions as a simple restatement of existing law, nothing more or less. The problem here is because of the Administrative Procedures Act, right here, that's it, that presented some kind of question about whether the court should defer to an agency interpretation of statutory law. This court cited Chevron just once. That's what it was. See, but this goes back to what Attorney General Barr was talking about, was these interagencies that the legislature creates and then goes over to the executive branch to be executed, and then they start through the Administrative Procedures Act, is the executive agencies get to create their own laws. Just a perfect example. The BATF, Bureau of Alcohol, Tobacco, and Firearms, they are the ones that did the ban on the bump stock. That was not Trump. This is a perfect example. Right here, right now, is the executive agency making legislation. Didn't go through Congress, and nothing to do with the president. This is what's been happening since the Administrative Procedures Act of 1946. This is the administrative state. And from a bird's eye view up here, looking down, what form of government does that actually resemble? Does anybody know forms of government well enough to articulate what form of government that actually looks like? What form of government does that resemble? Anybody? I know there's quite a bit of delay between when I'm asking the question and for it to get out there, and then for time for people to respond. So I'm just going to hold off on that, and I'll be waiting for some answers out there. What form of government does that look like? Does that resemble? Where the executive branch makes its own legislation and executes it and gets to interpret itself. Because that's what this was about, was that, well, the judicial branch doesn't get to interpret the statute, because that's what they're saying, that it was better left to the executive agency to interpret what the statute means. Why not the legislative? The ones who are supposed to have created it. But that's the problem. It's not the legislature that's creating it. It's all executive. It's all Administrative Procedures Act. It's a rule of procedure. No, form of government. Form of government. Johnny from Facebook says communism. That's an economy. That's a form of economy. That's not form of government. Form of government, folks. Form of government. Well, there's at least one out here that's got it. And possibly a second one. The correct answer is monarchy. You remember, our form of government has three, or supposed to have, three distinct branches of government. Remember our separation of powers doctrine? That no branch of government is to exercise powers properly belonging to another? Is that even in this? I don't know if it's actually in the federal. I know it's in my state one. It's a monarchy. A monarchy, remember having that mixed so-called legislative and executive? That's exactly what it is. So, it's a monarchy. Now, when we, what was Article 4, Section 4 supposed to be about? Do we remember? The United States shall guarantee to every state in this union a republican form of government, shall protect each of them against invasion, and on application of the legislature or the executive when the legislature cannot intervene against domestic violence. Domestic violence being that internal insurrection. And what does it really mean? Generally known as the Guarantee Clause, through its terms, the United States makes three related assurances to the states. Guarantee of Republican form of government, protection against foreign invasion, and upon request by a state, protection against internal insurrection or rebellion. Internal insurrection is what domestic violence is. That'd be that Luther versus Borden. This is a political argument, not a judicial one. An earlier version of the Guarantee Clause was among the resolutions of the what? Virginia Plan, introduced at the Constitutional Convention by Edmund Randolph and attributed to James Madison. The resolution went through several formulations. During the debates of the convention, during the key debate, Governor Morris objected to the resolution because He should be very unwilling that such laws as exist in Rhode Island ought to be guaranteed. Randolph explained that rather than cementing the existing laws of the states, the resolution had two objects: to secure Republican government, to suppress domestic commotions. Along with concerns about rebellions, delegates expressed fears that a monarchy might arise in a particular state and establish a tyranny over the whole United States. That's exactly what this has done. It's like, oh, we got a new novel concept here, the bar, because the Administrative Procedures Act, I've read through that congressional record on that, and it was all orchestrated and perpetrated by the bar. All proposed to Congress by the bar. And the intent was, to better secure justice. No, what you did is you stripped the power away from the people. You stripped the power away from the legislative branch, the direct representatives that are elected officials. Now remember, 1946. What did in 1906 in Hale versus Henkel, that there's a reserved right in the legislature to investigate its contracts and find out whether it exceeded its powers. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. The legislature is the one that's supposed to create. The legislature is the one that's supposed to provide oversight of what they created. And how does that happen? Oh, I don't know. Let's look at some real law. Rights as the law. The common law of the land. That all political power is inherent in the people. Government is instituted for their equal protection and benefit. And they have the right to alter, reform, or abolish the same whenever they may deem it necessary. And no special privileges or immunities shall ever be granted that may not be altered, revoked, or repealed by the legislature. That's them special privileges, right? Because this goes back to what's the difference between an individual and a corporation. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges. Special privileges. That's that business license or statutes, right? Now, further, right in the Idaho Code, statutes, the classifications of public and private. Statutes of public and private. A private statute is one that concerns only certain designated individuals and affects only their private rights. All other statutes are public, in which are included statutes creating or affecting corporations. The legislature is supposed to make the laws of its creation to regulate the corporations. That's why the law says that there's a reserved right in the legislature. And that's done through a petition to the legislature for the redress of grievances. The legislature is supposed to do the investigation, not the judicial. The judicial doesn't get to interpret what the executive agency's scope and authority is. The legislature does that. But that's the problem. Wow, that's some weird. Right, James? The bar is scrambled. They're now snitching on each other. Snitching or eating each other. Oh, yeah. Diesel D's, good to see you, brother. How's your mom? Hope she's doing okay. But this, again, back to our form of government, who has what powers. I know that in our let's see, state and separate part of the Union. The state of Idaho is an inseparable part of the American Union, and the Constitution of the United States is the supreme law of the land. Wait. In 1889, we had a union? Absolutely. It's the way it's supposed to be. In order to form a more perfect union, I guess it's in this one. I know it's in the Idaho one. Article 2, Distribution of Powers. The powers of the government of this state are divided into 3 distinct departments. Should be branches. But see, departments. That's corporation. That's a corporate term. The legislative, executive, judicial. And no person or collection of persons charged with the exercise of powers properly belonging to one of these departments shall exercise any powers properly belonging to either of the others, except as in this Constitution expressly directed or permitted. Not from an enactment. Plain and simple. No, Rob, that's how monarchy works, right? They only basically have 2 branches of government. The legislative and executive are mixed. They don't have a separation like we have here. Now, our distinct 3 branches of government first appeared in the Virginia Constitution, June 29th, 1776. Now, I called Attorney General Barr out on that when he was making his statements there, was talking about how, well, we didn't have 3 distinct branches of government until the federal Constitution. I call bullshit. It's right in the Virginia Constitution, June 29th, 1776. But this is why I'm trying to teach how things are supposed to be, so that we can tell what is unlawful and what is not supposed to be. That's not Republican in character and conduct. It's not part of our Republican form of government, our Confederate Republic. Okay? That's the key to all of this. We have to learn the truth so that we can tell what is unlawful. That's how I know that the Administrative Procedures Act of 1946 is unlawful, because I know who has what powers and who is supposed to exercise those particular powers, and how that legislation is completely unlawful and unconstitutional from its inception. And let me tell you, I've learned about it here in Idaho, experienced it, and questioned it. Clear back in 2019, and our own Attorney General here questioned it, and said at a GOP summer meeting there that we were at, Tony Pellegrino and I sitting next to each other, sitting in the room up there, listening to them to talk about this stuff, and our Attorney General, which I didn't know who that was at the time until I met him outside, I was like, who in the heck is this guy? Because he was telling him, like, look, the legislature is the one that has this power, and the legislature needs to buck up, make the legislation, and the executive branch can just deal with it. I'm like, what? I about fell out of my chair. I'm like, who in the heck is this guy? Because that's exactly what I've been talking about for, at that time, about 2 to 3 years, about this whole executive, we call it ADAPA, Idaho Administrative Procedures Act. It's the Administrative Procedure Act, implemented in the state. It's the same stuff. So, it's subversion of law. It's basically stripping the legislature of their powers to create and to control that which they create, and shifting the power to, see, and here's why. Because not all the members of the legislature are members of the bar. So it gets a little tricky for him to control all this, because certain people don't want to vote to pass that stuff. So what did they do? This is the bar, right? This is their line of thinking. How do we take control of all this? Well, again, think about this. Who sits over there in the corner of this executive agencies? I'll give you 3 guesses, and the first 2 don't count. James, you'll probably answer it correctly the first time. A couple of you out there might answer that correctly the first time. It's even in this case. When they're talking about, well, how did this Chevron thing come about? It was members of the bar. Members of the bar. They all have, all these executive agencies and everything, doesn't matter, corporations, whatever, all of it. They all have that member of the bar sitting over there in the corner. City council, all of it. All of that, everything that's made up, they've got the bar infiltrated. And then, why transfer the power from the legislative branch to the judicial branch? Half of the power goes to the executive agency, who gets to create their own laws of creation and interpret their own laws of creation when it comes to going into the judicial branch to be held responsible or for judicial review, and then get to dictate to the judge, well, that's not what, no. We get to interpret. That's what the Chevron case is about. The Chevron deference is that the executive agency gets to tell the judicial branch what the laws of their creation are and get to interpret it in their favor. And that the judicial branch doesn't have the power to interpret it. That's all this case right here does, is overturning that particular, the Chevron difference, where the executive agencies get to dictate what their scope and authority is to the judicial under review. They're the ones that get to interpret it. What this case did, said, nope, we're getting rid of the Chevron difference, and we're putting the power, according to the Administrative Procedures Act, into the judicial branch, the judges, to interpret the statutes. Huh. So that's again, what is at the root of our problem here? The bar, the Roman civil law, the code. The code is the law. They don't care about the constitutions. They don't care about anything. This is the bar infiltrating and doing what? This right here. Along with concerns about rebellions, delegates expressed fears that a monarchy might arise in a particular state and establish a tyranny over the whole United States. We'll all be darned. Answering Morris's objection, Madison moved to substitute language that the constitutional authority of the states shall be guaranteed to them respectively against domestic as well as foreign violence. Domestic violence, foreign violence. With Randolph then moving to add language that no state shall be at liberty to form any other than a Republican government. James Wilson then introduced, as a better expression of an idea, language substantially similar to the final form of the guarantee clause, with the convention approved unanimously. the dangers of turning us back into a monarchy. And that's exactly what happened. Because how does a monarchy work? Corporate charters. Corporations. The Virginia Company. The West India Company. The East India Company. The Northern Adventures Company. Company. These are all corporations. Even what we just read right there. Treasurer, Council, and Company of Adventurers and Planters for the City of London in 1621. That is a company, a corporation. When it says company, that is a corporation. Incorporated. In law. That's how a monarchy works. Okay? In our true republic that was created over time, starting right here, no, not necessarily LLCs, just company, period. Corporations. Now, for those of you that aren't aware of this, ever since the Reconstruction Acts of 1871, they created that corporation, the United States Inc., and all of the states converted into, instead of governments, all got turned into corporations, and they all redid their constitution for the state of. Instead of constitution for the government of, it became the state of. That's your corporate status, the company, corporations. Okay? So, back into a monarchy. That's the form of government. From a bird's eye view, what this looks like. Looks like a monarchy. But that's what Article 4, Section 4 is supposed to be about. And we're supposed to petition the legislature for the redress of grievances. Our right dictates that. It's even in the Declaration of Independence. We had petitioned with the most humblest terms, only to be met with repeated injuries. Blackstone's Commentaries on the Law of England. Due process of law. What does it say? I'm going to have to go. Oh, no, we're at 139. It was down to... I'm going to go right here because I know that's where it's at. Oh, this is good. This falls right in line with exactly what we're just talking about. This is Book 1, Chapter 2 of the Parliament, Section 146. We are next to treat of the rights and duties of persons as they are members of society. See, that's the governor, the lieutenant governor, legislators, Article 6, Clause 3, the members of the legislative, executive, judicial. Those are those persons created by the Constitution. Okay? They're the members of society. Not to be misconstrued as the inhabitants and the people. That's not a member of society. And stand in various relations to each other. These relations are either public or private. We will first consider those that are public. The most universal public relation by which men are connected together is that of government. Wow, that would be the Constitution, namely as governors and governed, or in other words, as magistrates and people. Of magistrates, some are also supreme, in whom the sovereign power of the state resides. Others are subordinate, deriving all their authority from the supreme magistrate, accountable to him for their conduct and acting in the inferior secondary sphere. Now remember, this is about England. In America, all political power is inherent in the people. The people retain all of the power. All of it. Now, the next part here. In all tyrannical governments, the supreme magistracy, or the right both of making and enforcing the laws, is vested in one and the same man, or one and the same body of men. Hello, executive agency, which they make their own legislation. Hello, monarchy. Parliament. And whenever these two powers are united together, there can be no public liberty. That's right. And wherever these two powers are united, the magistrate may enact tyrannical laws. The magistrate may enact and execute them in a tyrannical manner, since he is possessed in quality of dispenser of justice with all the power which he, as legislator, thinks proper to give himself. And that's what they were doing. And that's what they are doing. No, the Supreme Magistrate, Diesel D's, it is their, like the king. The king's bench, the king doing it from the bench. That's under a monarchy. That's how that works. That's the Supreme Magistrate, is the king. Where the legislators are in distinct hands, the former will take care not to entrust the latter with so large a power as may tend to the subversion of its own independence, and therewith of the liberty of the subject. With us, therefore, in England, this supreme power is divided into two branches, the one legislative, to wit the Parliament, consisting of the King, Lords, and Commons, the other executive, consisting of the King alone. It will be the business of this chapter to consider the British Parliament, in which the legislative power and, of course, the supreme and absolute authority of the state is vested by our Constitution. But see, now we're talking about common law, not under Roman civil law. Before the common law. But still, he talks about the Roman civil law and the code and how that all changes. But see, this is what the problem has been throughout history. But see, they don't have three distinct branches of government. They have two. But that's what they're saying. But see, you know, the king is the executive. And see, this is in part what's been trying to happen over time. But see, look, the Parliament consisting of king, lords, and commons. But then the king is also the executive. So it's not two distinct branches of government. Not if the king is involved in both. It's still just one branch of government. The original or first institution of Parliament is one of those matters which lies so far hidden in the dark ages of antiquity that the tracing of it out is a thing equally difficult and uncertain. The word parliament itself, parliament or colloquium, as some of our historians translate it, is comparatively of the modern date, derived from the French and signifying an assembly that meet and conferred together. Would that be that General Assembly that they were talking about in 1621? Instead of calling it Parliament, because that's more of an English term, they called it the General Assembly. Imagine that. It was first applied to General Assemblies of the States under Louis VIII in France about the middle of the 12th century. Of the States? In 1100? Which states? But it is certain that long before the introduction of the Norman language into England, all matters of importance were debated and settled into the great councils of the realm. Well, they still called it, even though he's saying General Assembly here, he's using the French stuff, it was still Parliament. They called it Parliament. Now, Parliament, yes. That's in part what happened there with the Aziz of Clarendon. And the original jury stuff was the legislative branch. And that's actually in this book I still have sitting here on my desk right now. Bills, Quills, and Stills, an annotated, illustrated, and illuminated history of the Bill of Rights that I got from the gift shop when I visited the Supreme Court of the United States of America back in September of 2018. The original juries was the Parliament, or General Assembly, and was upwards of 600 people. In the legislative branch? Well, that's interesting. That the legislative branch was the grand jury? And that trials were held in the legislative branch? Or what we would consider the legislative branch at that time? I mean, let's look at Lex Parliamentaria Americana. I have it pulled up right here. Of the incidental jurisdiction of legislative assemblies, civil jurisdiction, criminal jurisdiction, jurisdictions of contempts, of the mode of proceeding by legislative assembly in the exercise of its judicial functions, civil proceedings, criminal proceedings, proceedings in cases of contempt. In what manner the judgments of the legislative assembly are enforced, of the punishments which the legislative assembly may inflict, fine, imprisonment, reprimand, expulsion. Holy crap! What do you mean the legislative branch has the power of judicial, civil, criminal, and of contempts? Holy smokes! There's a lot. There's a lot that has been subverted, changed, altered because of the bar. Because this gives too much power to the people. And they didn't like it. That they didn't have that control, because then the people were indicting them and removing them, the bad guys. And of course, it worked so well, they just couldn't have it. So Isn't it quite interesting to see this right out of Lex Parliamentaria Americana, which is the elements of the law and practice of the legislative assemblies in the United States of America? This is the book of law, the common law. Oh, this doesn't have anything to do with statutes or code or any of that. Again, I keep trying to explain to people that there is a common law side to our republic that comes before the Constitution, that has a direct effect on form of government and who has what powers. Bingo. Comment made over here. That's why they had to take control of our free public education, so we didn't learn about this, right? That's right. That is absolutely correct. Read Rules for Radicals by Saul Alinsky. To take over the education, take over the medical, take over the economy, take over this, take over that. That's how to take down a nation from within. And make no mistake, people like Hillary Clinton, Obama, Bush's, they all read that. They know. Okay? And that's what's happened. But the reality is it's the people that have been derelict in their duties and learning this for ourselves and maintaining that education in our schools. So it's our own damn fault. We cannot blame somebody else for our lack of knowledge. As much as I'd like to try and put that blame on somebody else, it belongs where it belongs, squarely on the people. Okay? And that's one reason why I'm out here. I'm trying my best to educate the people, wake the people up, and read real law, history of law. Get out of that frickin' code and read some real law and history of law. Real law. Right? Now we're learning about history and our rights the hard way. Well, I don't know if we're learning about them the hard way. I'd say that we're learning that they're corrupt. Not many people actually know about their rights. Even those out there that claim that they're fighting for it. And, oh, hoorah, we made some legislation this year. We got some legislation passed on what is it? Religious exemptions. Oh my gosh. Yep. Idaho now has legislation that says, hey, we have the right of religious exemptions. And no school and blah, 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 blah can subvert that, basically. And I'm like, but it's already the law. I mean, if we read our state constitution, and more specifically our Declaration of Rights, under that religion, which is Article 1, Section 4, guarantee of religious liberty. It says, the exercise and enjoyment of religious faith and worship shall forever be guaranteed. Semicolon. And no person shall be denied any civil or political right, privilege, or capacity on account of his religious opinions. But the liberty of conscience hereby secured shall not be construed to dispense with oaths or affirmations, or excuse acts of licentiousness, or justify polygamous or other pernicious practices inconsistent with morality or the peace or safety of the state, nor permit any person, organization, or association to directly and indirectly aid and abet, counsel, or advise any person to commit the crime of bigamy, polygamy, or any other crime. Now imagine that. Liberty of conscience. Where in the heck does that actually come from? Oh, would that be them laws of nature? The law? There's some law. Religious exemption. If people were just to read that, they should get a little bit out of that. But I can tell you right now, this helps out a lot. Where is it? There it is. Right here, there's them five elements of that right of life or personal security. Number 4, the preservation of a man's health from such practices as may prejudice or annoy it. Huh. I mean, I know it's really short there. But there's more to it, because we're talking about free will. At present, I shall only observe that whenever the constitution of a state vests in any man or body of men a power of destroying at pleasure, without the direction of laws, the lives or members of the subjects, such constitution is in the highest degree tyrannical. And that whenever any laws direct such destruction for light and trivial causes, such laws are likewise tyrannical, though in an inferior degree. Because here the subject is aware of the danger he is exposed to, and may, by prudent caution, provide against it. The statute law of England does therefore very seldom, and the common law does never, inflict any punishment extending to life or limb unless on the highest necessity. And the Constitution is an utter stranger to any arbitrary power of killing or maiming the subject without the express warrant of law. Says the Great Charter, nullus liber homo. I wish I could translate that. Which words, according to Sir Edward Coke, including a prohibition not only of killing and maiming, but also of torturing, to which our laws are strangers, and of every oppression by color of an illegal authority. And it is enacted by the statute 5 Edward III, c. section 9, that no man shall be forejudged of life or limb contrary to the Great Charter, and that the law of the land, and again by statute, that no man shall be put to death without being brought to answer by due process of law, from the law of the land. But again, how many people actually know this? Not think they know, but actually know it. That is different. That is the difference. You believe you have these rights, but do you know these rights? Well, I wish I could find that spot Maybe I did. I. Yeah. But again, do you know these rights? Do you know? Yeah. It just. I wonder if it's. That's on civil death. I thought this was on absolute rights. Maybe it was down below. I can't remember. But about that free will, that liberty of conscience, right? All right, folks, getting close to that time. So, all right. So let's go. Let me see. Let's go over here to the nationalassembly.net. This is where we're gathering, folks. This is the website, national-assembly.net. There's a conference call every Thursday night. That's on this tab here, conference call info. Again, highly recommend people download and install the app. Free conference call. If you're on your smartphones, here's a tutorial video on YouTube to watch and learn how to do that. You can also install it on your desktop computer or laptops. Okay? YouTube video for that. Here's the link to join the meeting. That is actually the link. Right there. And then if you install the app, you'll also get to see the screen share when they do screen shares. You're welcome, Jax. Thank you. Much love. God bless. So the thing is really need to have this app to really interact. Okay? And we really, really, really need the people to come together and reassemble government de jure. These are the ones that have the legitimate, lawful process, documents. Nobody else has done this correctly. These are it. I've researched, I've looked for the right one for many years. Okay, I'm aware of some of these others out there that seem to think American State National and all of that. Oh yeah? Well then how come they're not in control? How come the military doesn't recognize their authority? How come the military recognizes their authority here? The National Assembly folks. Michigan specifically. And Alaska. Because those are the two that have actually lawfully reassembled government de jure. Now, they were well on their way, getting very close to having the sufficient amount of states in interim until Anna von Reitz infiltrated. And make no mistake, Anna von Reitz, she wants that information on how to do it right so she can have that control. But sorry, you got your blood oath bond to the Pope and Vatican. And that's actually on here as well. As well as her information about her husband being a 2-time convicted child pedophile. As well as state national fraud right here, which was composed by me. And I lay it all out. I show you the code, where it comes from, the etymology, and again, American state national. It's like, well, what is a state? The term state includes District of Columbia, Puerto Rico, Guam, the Virgin Islands of the United States, and the Commonwealth of the Northern Mariana Islands. Again, the United States of America is not here. So what state are you an American national of? Would that be District of Columbia? Puerto Rico, Guam, the Virgin Islands? Or the Marinara Islands? Or Marina Islands? I don't get it. Clearly, these people are not reading this. Plain and simple. But this is it, folks. National Assembly forums. You want to get on here and introduce yourself from a particular state? Where is that? What? Oh, there they are. Okay. Scroll down a little bit and get to the 50 nation states. Here they are. Get into your particular state. Do your introduction. And get connected. Get on the call. Thursday night calls. Okay? We really, 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 really need the people to come together and reassemble government de jure. There is no if and or buts about it. All political power is inherent in the people. We have to reassemble the people. Okay? And then for me, let's see. We got here on the homepage of my kirkslawcorner.com, Facebook, Telegram, Patreon, YouTube, Rumble, and X, which as of tonight, we're back to being on YouTube. So all 5 places we're broadcasting live right now. Facebook, Telegram, YouTube, Rumble, and X. Subscribe to my channels there. Now, Patreon, I do hold private classes on Wednesday nights. Free educational series on YouTube. This gets you the link. Watch on YouTube. This will get you a link to the first episode. Then there's actually more than 8 now. There should be 11 in there, 11 or 12. Now, Patreon. If you go to the Patreon and you want to, donate through there, like a monthly donation, I've got Tier 1 set up for $5 a month, Tier 2 set up for $10 a month, basically a cup of coffee a month. Okay? Just to help support me in paying all the bills it takes to do all of this that I do for free out here. Okay? If you want further, more in-depth education and get in on learning about what I'm actually doing in my own personal cases and how to do some of this stuff for yourself, the proper paperwork that needs to be done, that's Wednesday night workshop. Okay. If you're looking for help, I have Tier 4 set up for one-on-ones. Okay. That's Tier 4. Now, for those out there that keep asking personal questions about your own case and that stuff, that's what that's for. I'm not going to be doing it over here on Telegram or Facebook or YouTube and all that. You can either get into Wednesday Night Workshop and learn more there, watch the free educational series, or you can go read on your own. That's under the library tab. Otherwise, for all other donations, any of those postal money orders, regular money orders, cash wrapped in aluminum foil, any gold and silver coinage, you can send that to me over here at the office. Address is here on the website. 6477 West Fairview Avenue, Suite G as in golf, Boise, Idaho 83704. I want to thank those that did a recent donation over there at the office. I greatly appreciate that. So this, they've taken down my PayPal, my Cash App, my what's the other one from Venmo? This is just basically PayPal. So this is it. This is what I use is through Patreon and through direct donations to the office. Okay. Other than that, go to the my library tab here for books. I really need to find a matching set of Blackstone's commentaries on the law of England, because I have volume 1, which is book 1 and 2, and then volume 2, which is book 3 and 4 from different years. So they're different revisions. So I need to go back onto archive and find 2 good, decent copies that match, and get them uploaded on here, because that is such a very good read. It's like it needs to be like right here next to Treatise on Arrest and False Imprisonment, because it's fundamental. It comes before Constitution. All right. Other than that, folks, I hope you have a wonderful night. Hope you had a great Independence Day weekend. Stay warm. Oh, stay cool. We're into super hot weather, up over 100 degrees. We've been right at close to 100 degrees this last week during the day. It's getting hot. So stay hydrated, folks. And of course, to all the prayer warriors out there, I ask for your prayers and guidance out here, protection. Pray for the world peace. But God bless America, God bless the world, God bless mankind. Thank you all for being here and your kind words and support. I greatly appreciate it.